Afternoon, everyone. I see there's about 3 minutes left, so I'm just giving the last few people chances to join, then we'll start at 4:30. Okay. Good afternoon, everyone. Just a reminder that the webinar is recorded, and then Grace will, after the webinar, published on the website for you to refer back to if needed. Just a quick note on why we postponed. It seems there are few candidate attorneys also doing this course, and they were writing exams last week, and some of them requested that we can maybe move it. So to accommodate them, we just moved the webinar to today. So thank you for your understanding and patience, and hopefully those candidate attorneys, we all get 90% from them. Then two things that we will deal with tonight or this afternoon is I just want to give you some feedback on your first assignments, and then we will look at some other amendments to the Children's Act and how it impacts on the material of this course. I just want to quickly check. I did publish the amendment bill on the website. Could any of you access it? Is there troubles with the document?
No, it was good.
Yes, Karen.
No, I'm just saying I could access it, no problem.
Oh, sorry. Oh, can you hear me now?
Yes, I can hear you.
Oh, okay, because I see there's a problem with the audio from my side. Oh, okay. Yeah, I was just asking, I said I did publish the amendments on the website. I just know if you could get the document and download the document.
Yes, I was saying yes, I can.
Okay, sorry, thanks. Yeah, I see the audio was a problem from my side. Now it's fixed. Okay. Then, as I say, I wanted to give feedback on your assignments, your first portfolio, and then also look at some other amendments. Yeah, the papers have been graded and everything. I have a bit of a technical challenge uploading your scores and the feedback assessments. I will try to sit down with Grace first thing tomorrow morning to see if we can sort out the glitch so that you can get your marks and your papers back. I think you will see on average everybody did very well, so congratulations. For you that maybe do not do so well, there's two main reasons, and that is that some of you answered the wrong question. I don't know where the misunderstanding came in, but there's the wrong answers or wrong questions that was dealt with. And then some of you only answered one question. So I then only marked the one question, but still out of the same total. So that you will see caused some people to do not so well. And then with regards to the third question, with regards to the rights of the unmarried fathers, most of you stop short of looking at section 23 as an option to also get rights. And then there was only the one person, and I forgot now who it was, who actually also mentioned adoption, which unfortunately in some circumstances is the only way that an unmarried father can get rights in terms of his own child. Those are the extreme cases. It's not the run-of-the-mill cases, but those things also happen. So yeah, just to give you a quick feedback, but with regards to the first two questions, everybody got the gist of it, and you did very well. So thank you very much for that. Any questions with regard to your assignments? No questions.
I see that the marks for the best interest is up already. Did you portion that separately?
Oh, no, I did not do that.
Oh.
Okay. So I don't know. No, because no, because I mean I gave it each question has a separate mark. That's true, but I work out the total percentage based on all three questions. But it might be that the system, because I do save it separately, so as your submissions is saved and the feedback is saved as a separate document. So, but I'll check with Grace. Maybe the system then extracts the mark for the first question.
Okay.
So yeah, I don't know if Grace is usually here. I don't know if she has time, if she joined us.
Hi, Elizabeth.
Hi.
Hi, this is Lerato. Sorry, I can't raise my hand here. I don't know what happened.
No, don't worry about it. I can see your name.
I also got a mark for that part 1, best interest of the child. But okay. What happened is I actually submitted that on its own, and then later retracted it and submitted the full portfolio. So I think you marked that part that was separate from the full portfolio.
Okay, I'll make a note and I'll just go and look at yours specifically, but Lerato, I cannot recall that, but maybe it's a good thing that you mentioned it. Let me just go and have a look specifically about that.
Okay, all right.
I see somebody's hand is up. I can't see whose, so just speak up if you have your hand up.
Okay, hi, it's me, it's Janice.
Yes.
I'm sorry, I joined a little bit late, so I didn't hear your answer to, I presume it was a similar question where I've just received 1 mark for the best interest, but I haven't received marks for the other 2.
Okay, yeah, I think Karen also raised it. I said to her, I don't quite understand, but maybe my own ignorance in terms of not knowing how the system deals with my feedback. I don't know. I don't see Grace's hand or name. So I will, I will discuss it with her because I had technical problems in uploading your scores. So maybe she did something from her side. So I will double check then why that score went through, but not the rest of the other two questions.
Okay, thank you very much.
Elizabeth, sorry, I can't raise my hand. It's Leander. If I can just say, there's been a score for best interest since the start. A mark for best interest since the start of the module. So I think that's just a technical glitch. I think probably everybody has a best interest mark, even though it hasn't been marked. So I think that's just a technical error on Grace's
error.
side.
Okay.
Yeah.
So no, that makes sense because I don't see, if I had a problem uploading your scores, how this, how there would be a score for one question only.
So are you saying then that we don't have any scores if you've had that problem?
Yeah, that's why I say I have your scores. I shared it with Grace, and also the marked assessments, but I couldn't upload the scores from my side because I need to upload them. There was a technical error this morning, so I still need to sit down with Grace to just sort it out.
Okay, thank you.
Okay, any other questions with regards to portfolio 1?
Okay. Did you make any...
Just one more question. Sorry, Janice, I'm not able to raise my hand. I just want to find out with regards to portfolio 2, are questions 4, 5, and 6 the questions for portfolio 2?
I don't have that list in front of me now. Let me quickly, because portfolio 2 consists of, I know Grace and I played around, but it did the activity as she has published it. That is the portfolio 2.
So just to confirm, it's 4, 5, and 6. The activities published under 4, 5, and 6.
Yeah, that would then be portfolio 2.
Okay, thank you.
Okay.
Maybe I missed it also, but did you make any general comments about the assignments?
Oh, yeah, is it Janice?
Yeah, sorry.
Yeah, no, I just said that with regards to the assignments, overall, you will see all of you did very well. The few of you that scored maybe a bit less, there was a few of you that had the questions wrong, that submitted answers to totally wrong questions. And then there's some of you that only answered one question instead of 3. But on average, everybody did very well. And I was also saying that with regards to the third question that dealt with unmarried fathers, the majority of you stopped just before section 23 and didn't consider section 23 as also an option. And there was only one of you that looked at adoption as also a way of getting rights. I think in extreme cases, that's unfortunately the only route for an unmarried father to go to get rights, although that's not the general route, but sometimes that is the only route. But there was only one of you that mentioned that, but I could see from the answer, it was somebody that dealt with it in practice. So it's one of the social workers that had to do an adoption of a child for an unmarried father. But overall, the answers was very good. So thank you for that. Okay, anything else before we move on? Yes. Okay. I'm just going to turn off my camera so that I can share with you the presentation. Okay. You should all be able to see it now. So just again a note that you will see, and that's also why I shared the whole amendment bill with you, that again, from the amendment bill, I only highlighted the relevant sections that I would think that is relevant to the material we are looking at. Again, there's a lot of amendments that deal with early childhood development, with CYCCs, with things that we are not looking at particularly, but that if that falls within your scope of practice, you can have a go and have a look, and that's why I shared the document with you. And there's also some amendments to the Hague Convention on the offences, again, which I did not deal with you because sort of if this would make this presentation very long. So just please go and have a look at it at your own time. Sorry. And then I made a note for myself to go and see if we have an implementation date yet, but I haven't been able to find that date, but if I have, then I will also share that with you. I don't know if any of you have any feedback on if there's a bill was approved or not. Okay, so let's start with section 46, which then is orders a children's court may make. And you will see that they've inserted into a new section 1CA, which is now another kind of order that the children's court can make. That is for the assignment, the exercise, the extension, the restriction, the suspension, or the termination of parental rights responsibilities in respect of a child. I think this is just also a bit of a clarification, because in any way the section deals with termination of, the court can in any way terminate somebody's parental rights responsibilities. Then in terms of lay forum hearings, substituting section 49(1)(a), that mediation by family advocate, social worker, social service practitioner, or other suitable qualified person as may be prescribed. You will see as we go on, a lot of the amendments that follows, they have taken out certain words when it comes to the people that are qualified to do mediations, and they have inserted in a lot of the subsections. You will see this word as this idea of as may be prescribed. So the idea that I get is they want to make the pool of people that are qualified to do mediations, they want to increase that pool of people rather than restrict it, because a lot of the wording of the section previously was more specific with regards to the type of people that can do mediation. So I think that the idea, you'll see a lot of the amendments make it a bit wider. Then section 52, rules and court proceedings. So I think you are quite aware that currently there's no rules for the children's court, which makes it difficult, because if you want to do something in the children's court, you must go and scratch around in the rules of the magistrate court to go and see how to do something. So now specifically, the same rules board must make rules for the children's court. And I know the draft rules have been circulated last year. I haven't seen any further drafts, but they are busy with that. Then 52 makes provision that an interpreter can be used, but also the use of a suitably qualified or trained interpreter, including a sign language, speech, or tactile interpreter. So it's just an adding, it's more a description of the kind of interpreters. So in terms of 52.3, it says that yes, except where otherwise provided in the Act, and except where the rules for the children's court does not provide for it, the rules of the magistrate court will still apply. So although there will be rules for the children's court, one would not be able to ignore the rules of the magistrate court altogether. One will have to make sure that if there's a gap in the rules of the children's court, that we still go back to the rules of the magistrate court. Then 57, section 57 deals with compulsory attendance. So the clerk of the court must give notice for a family member to attend or a person who has an interest in the matter. And then a person whose care the child is must bring the child to court unless otherwise directed. Now I know on the people present here, there's a lot of people from different jurisdictions. I know I appeared in the Phalaborwa Children's Court a few years ago, and that presiding officer insists on the children to be present. But I think overall, a lot of the general practice is that children are excused unless otherwise, or unless the court asks them to be there specifically. But this subsection then makes provision that the person in whose care, and the replacement there, or the change is the word care. Because previously 57 spoke about the person in whose physical control the child is. You must bring the child to court. So this is more in whose care the child is. Must bring the child to court. So I'm not sure if this amendment makes it easy or more difficult, but that's now how the proposed amendment reads. Then professional reports, section 62, replacing the existing 1E, 62 1E. Again, currently it reads the person under whose control the child is, to change to investigate the circumstances of the person in whose care the child is. So again, this idea of whose control is taken out to be replaced by care. And then substituting 62.2a to obtain supplementary evidence or reports from other suitably qualified persons as may be described. So again, that little the inserting of the words as may be described. So again, the idea that the pool of people that can be suitably qualified can be then expanded to make provision for more suitably qualified persons, and these kind of prescriptions usually take place in the regulations, so they will have to amend the regulations to make provision for this. So evidence, amending section 63.1 to read as a written report compiled and signed by a medical practitioner, psychologist, family counselor. So what they've done here is inserted the word family counselor, family advocate, designated social worker, or suitably qualified person as may be prescribed. Again, the idea of as may be prescribed. So it's not just a limited list. There can be other people inserted. Publication of information, section 74. So that whole section is now deleted. The publication of information with regards the relating to the proceedings. So no, there may be no publication of any information, because the old 74 say that there could have been publication with permission of the court of a certain information. But the section has now been deleted in toto. However, section 66 still deals with the record of the case. So that will be the court file. So in certain instances, some people can still have access to the court file, but 66 has a specific list of the people that can have access to court files. So, for example, somebody that's busy with research must be able to prove to the court that they're doing bona fide research and they can have access to the case records. So, but the publication of information has now been deleted. So 76, which deals with partial care, has been then placed in toto. 76 has been scrapped and then replaced with partial care is when a person takes care of more than 6 children on behalf of their parents, guardians, caregivers during specific hours of the day or night or for a temporary period by agreement, but excludes full-time care of a child by a school, a hostel, or a hospital. So you remember in terms of the orders that a children's court can make, the children's court as an early intervention service can say that the child must be placed in partial care. So the court will say maybe the evidence has shown that this child during the day is left by him or herself, and that is when the child is in danger or being neglected. So the court can order that the parent or the caregiver must then place the child in partial care for specific hours to address that issue that the social worker or in the investigation has raised. But it excludes the full-time care by a school, a hostel, or a hospital. So your boarding schools, those would be excluded as partial care. Reporting of abused or neglected persons. So here, what you've done, you can see from my notes, there's a certain list of people that have an obligation to report neglected or abused children. So what they've done now is they have added some people to that list. So the people that are added is the ones that I've underlined here, is to say an officer of the court, an official in the employ of the Department of Home Affairs, a social service practitioner, any person working with children or a ward counsellor who on a reasonable ground suspects that the child has been abused must report that suspicion. So if we just look at the old wording, or as it reads now, it talks about must report that conclusion. So the section now reads that conclusion in the prescribed form. So what they've done is they've replaced the word conclusion with ground suspects, or the suspicion must be reported to an organization or DSD or SAPS. So in terms of 135 deals with the application to terminate parental rights responsibilities, which in terms of 135, the DG or the provincial head of DSD or a designated child protection organization may apply to the High Court, the Regional Court, or the Children's Court for the suspension of rights or the restriction or circumscribing the exercise of rights. So I was thinking here in line with maybe a child that is in a child or youth care center, that the Department of Social Development as the overseer of that children's home can apply for the suspension of the rights of a parent if that parent maybe oversteps their bounds, is a danger to the people or to the children. So in my opinion, I think the section gives that option to social development or the child protection organization to protect the children that are in their care, and maybe to make it a bit easier to also protect the children. So then section 150 that deals with the child in need of care. So there they have substituted some of the, I think this the section talks about when a child is deemed to be a child in need of care, and then the Act lists a number of circumstances of when a child deemed to be in need of care and protection. So first, 1A, they've replaced A child is in need of care and protection if the child has been abandoned or orphaned and has no parent, guardian, family member or caregiver who is able and suitable to care for the child. So the replacement here is because currently it reads the whole idea of who is able and suitable. That's the new idea that is brought in. Then also the 1I is substituted with a new one. A child is in need of care and protection if the child's being maltreated, abused, deliberately neglected, or degraded by a parent, caregiver, a person who has parental rights responsibility, or a family member of the child, or a person whose care the child is. Because in the current one, I just want to make double sure that I've just deleted some words of and whose control. Again, what they've changed is to say that in whose control the child is. So again, deleting that idea of who control, but say in whose care the child is. So they've also added, they've added 3 new grounds on which a child can be deemed to be in need of care and protection. And if that child is an unaccompanied migrant child from another country, if a child is a victim of child trafficking, or if the child been sold by a parent, a caregiver, or a guardian. So those 3 grounds have been added to 150 as grounds. Then 155, I think the amendment here deals with some of the time periods, because I think also, you know, in practice, there's been a lot of debate about the 90 days and when does it expire and who must do 90 days and postponements. So in my opinion, I think the proposed amendments is trying to speak to those time periods and maybe make it a bit more clear about when the 90 days lapses and who's responsible. So 1552 is substituted to say a designated social worker must investigate the matter and within 90 days compile a report on whether the child is in need of care and protection. So if on my reading of this, the designated worker have 90 days to investigate and then compile a report within 90 days. So 1552 as it read now, and I think that's where the confusion came in. I just quickly want to get to it. So because 1552 read at the moment read before the child is brought before the children's court, a designated social worker must investigate the matter and within 90 days. So they've deleted that before the child is brought to court. So that restriction is not there anymore. And then 1555 is replaced by if after an investigation the social worker finds that the child is in need of care and protection, the child must be brought before the children's court for a hearing, upon which such court must make a determination. So 5 at the moment. The words the must make a determination is not part of the current section. Again, I think a lot of times there's an investigation and the matter goes back to court, but there's nothing to say what the court must do. So for me, again, this is maybe just clarifying the process a bit better to make sure that the process is finalized. Then by another, in terms of the process, 1556 is changed to say what kind of orders the court can make. The court hearing the matter may adjourn the matter for a period not exceeding 30 days at a time. Again, in practice, I don't know, there's different practices in different jurisdictions, but this postponement period the 30 days in terms of court roles, I don't again know how practically enforceable this is, because a lot of the courts, the roles are of such a nature that you can't postpone for less than 30 days. It's just not placed on the court roll. So again, I don't know if this really solves any problems. But while they, then the court can make an order if they adjourn it to keep the child in safe care, transfer it to another care, or temporary safe care, keep the child where the child is, be placed in the care of a family member, be placed in temporary safe care. So also then if the order is, if the child, the can must be returned to whose care the child was removed before the removal. Just to go back to the previous one, 1556, that was later on. There's also an order now that is not in the Act currently, that a person or a safe care, alternative care, is also a family member or a relative that the child can be placed with. So 15, by inserting in terms of section 156 CA, there's a new order that the court can make. The child can be placed in the care of the parent or family member if the court finds that such a person is a suitable person to provide for the safety, because that is not currently there. And then currently it says that that person or the place of safety must be a registered place of safety. So you have to place the child with somebody that is approved. And in practice, it is a problem because those places are usually full. So I think this inserting of the new subsection is trying to alleviate that problem, because a lot of times there are family members who are willing to get involved, but then if you look at the other requirements of a place of safety, they don't meet that. So here it says that can be placed with a family member if the court finds that such person is suitable. So again, I think the court has a duty to at least make sure that that person is a suitable person, and surely a suitability can be done by an investigation by a social worker, just to say, yes, I went there, the person is staying here, circumstances seems appropriate, the child can temporarily stay with the family member. So I think this is just a practical solution to a problem they have at the moment. So 157 deals with orders aimed to secure the stability in the child's life. So substituting 1573 to have, because currently the mention there of the 3 years is not in the Act. It just says a very young child. So which is very vague. So now it says a child with less than 3 years of age who has been orphaned or abandoned. Just this to make that more easily determinable. What child are they talking about? Who has been orphaned or abandoned must be made available for adoption in the prescribed manner, except where this is not in the best interest of the child to be put up for adoption. So 1592 big A is then a new order that the court can make. And again, I think this amendment follows the big problem there was with the foster care orders. And I think you're all aware of the big administrative issues there was with foster care and lapsing of foster care orders. So here the Act now gives the court may extend an alternative care order that has lapsed, or make an interim order for a period not exceeding 6 months on good cause shown. So I think this is just a section that gives the Children's Court statutory powers to address the practical problem that that happened with Department of Social Development and foster care placements. Okay. As I say, there's I didn't want to bore you too much in terms of all the amendments. I think the rest of the amendments is something you can maybe just go and have a look at yourself and see in terms of how relevant it is to the work that you do. I thought those were the ones that you might have to deal with in practice the most. I have shared the presentation with Grace, so she will publish it also following the webinar today. Any questions? Yes, I see there's a hand. Ms. Mutata?
Yes, hi. Can you hear me?
Hi.
So when I did this, it's actually a question that's like out of what we're speaking now. When I did this child law course, I did it when because I had a matter in the children's court in Hammanskraal, where the father was suspected of committing crimes, but the police could never prove it. Also, on the other hand, the prosecutor didn't want to close the case because they were afraid that if he actually did it, so everybody was kind of up in the air about it. It went to the family advocate's offices twice, and the family advocate says we will make a recommendation after the criminal proceedings are done. And the matter was before the senior prosecutor for SPP decision for I think a year, and then I left the firm. I was always wondering, what is it that you can do differently when you have a mother that's trying to protect her son from these allegations, or protect her son from this kind of man, but the court is not willing to take away parental rights of a father?
I think for me, I think the courts linked the two, the criminal prosecution and the children's court, and I don't think that's always necessary. I mean, you don't have to find somebody guilty to terminate parental rights, because I mean the tests is two different tests. So if there's, I mean, in a criminal court, you know yourself, I mean, you have to prove it beyond reasonable doubt, which is it's a very heavy burden to rid yourself of. But in the children's court, it would be just to show what is in the best interest. So an application just to terminate, and then just look at the relationship, you know, what is those best interest standards, which one, is there a relationship between the child and the father? Is there a possibility that the relationship can actually maybe be amended? Does the child want a relationship with the father? So I think there's other criteria that you can apply in the children's court to bring an application to say, yes, he hasn't been found guilty, but in terms of emotional, in terms of physical, you want to terminate his rights because it's not in the best interest of the minor child.
Okay. All right, thank you.
I see. Okay. I think it's Elmarie that had a hand up.
Yes. I do not work with child youth care centers and the like on a daily basis. So can you just explain to me what is the difference between partial care and then a youth care center and the other one?
Okay. Okay, so a CYCC is what we would have called in the old terms a children's home. So a children's home would be alternative care placement if a child is then found to be in need of care and the child has to be placed alternatively, then a child or children's home or CYCC is in a place of alternative care. So, but partial care would be, like I said before, if there's early childhood in child or early intervention services. Typically, that's why I use the example to say that, for example, the father is the primary caregiver, but he works from 6 to 8 every day, and then he would leave the child all by himself or herself at home. And say the court would then get involved and there's an investigation, the court can say, no, sir, you cannot do that. I'm ordering you in terms of a partial care order, that this child, while you at work from 6 to 8, you must have the child in a partial care facility. So that is partial care.
Okay, thank you.
Okay. There was another hand up. It shows me 2. Janice, is your hand still up or? Oh, yeah, Janice, is your hand still up? Oh, okay. Is there other questions or comments? Okay, Leroux, Marie Leroux.
Hi, sorry. My question is not regarding the webinar, the current webinar. It's regarding the marks for Portfolio 1. I just want to know when the marks will be published so that we can know if we are on the right track with the portfolio. Sorry, I logged in a bit late.
No worries. No, don't worry. I see there's a few people that came in late. I've marked all the papers. I've graded all of them. I was to upload it, but there was a technical issue from my side. So Grace and I will try first thing tomorrow morning just to sit down and see where's the problem, where I go wrong. I'm sure I'm clicking somewhere on the wrong button, but all the papers have been graded. I think the feedback that I gave to the group was that everybody did very well. There's a few people that answered the wrong questions altogether. And then also some people only answered one question instead of all 3, which I then unfortunately could not give them marks for something that did not answer. And then with regards to question 3, the one about unmarried fathers, a lot of people didn't consider Section 23 applications, which would also be a way of getting rights and responsibilities, and then also adoption. Although adoption for an unmarried father would be your last resort, but there can be circumstances that it would be his only way of getting rights with regards to his own child is to go the way of adoption. But overall, everybody did very well.
Thank you.
Okay. Any other questions?
Elizabeth?
Mm.
Hi, it's Lerato.
Yes, Lerato.
Yeah, can I take you back a bit to the amendments that 155.2 about the 90 days? When exactly do we start counting? I know it's not a cut and try thing, but when exactly do we start counting the 90 days? From the time the social worker receives the report, or from when? Receives the information that the child is in need of care?
Yeah, I think that's what the amendment tries to do. If you look at the amendment, it now says she has 90 days after the investigation. So
okay, so it extends that period.
Yes, because I think previously, if I quickly want to just lay my hands on the, it gave the sort of when it was reported, she has 90 days, which led to a lot of practical problems, because I know then when you come in court, then the people would want to say, no. But the 90 days have long since lapsed, and, you know, this investigation is not, it's not finished, and the 90 days are here now, so the court must now close the case. So I think the amendment is in some way trying to give the social workers a bit more space to do the investigations.
Oh, okay.
Thanks. I see another hand. I can't see the name, so Shantay. Yeah, there you go, Shantay.
Hi. I know this is also a very not relevant question to to today's meeting, sorry.
Okay.
Matter on Thursday in the children's court, where the grandmother wants access or contact with the grandchildren because the mother refuses, okay? And I've been reading quite a bit of case on this, and I just feel like it's very up and down, because the one case will say, yes, it's in the child's best interest to have contact with extended family. The other one says, no, it's not. It's such a iffy topic. And so I was thinking of doing it in terms of Section 7 and Section 23, and then also relying on a recent judgment where the court said it is in the child's best interest to have the grandparents part of their lives. However, it is supervised and very controlled, because the children haven't seen the in this case now, haven't seen the grandparents for 3 years, so it's going to be integrated slowly, where in my matter, it's just a year.
Okay.
Do you agree with that?
Yeah, I agree with you. I also recently had a case of grandparents, and I also looked at the case law, and I agree it's very conflicting. It really almost depends on which division of the High Court or province or area you are. And I think generally, if you look at some of the earlier case law, it says also that the contact between the children and the grandparents must not lead to conflict. Because if there's conflict, then that contact can clearly not be in the interest of the children, because that's not stable, and it just ups in their normal routine and their normal life. But I think I agree, if there's been a year lapse and the court, and you say, well, it is in the best interest, you might be more successful if you can say to the court, let's first see how it goes, rather than just storming in and say you want alternative weekends or 1 weekend a month. So it might serve you better to make it a bit more slowly, and also maybe fewer, or make farther apart, so that the court might feel that you're not disrupting the children's lives so much by coming now and say you want rights, your clients want rights.
But if the parents just outright still refuse, is this something that you would refer to a social worker for advice? Or how would you actually determine what is the best interest of the child, when both parties are so far apart?
Yeah. Does the child have their own legal representation?
No, not at all.
Yeah. Well, that's also a way of going about it, to say, what does the children want? I don't know how old the children are in your case. But I mean,
one is
pardon?
2 and the one is 7. Sorry. The one is 2 and the one is 7.
Well, I mean, the 7-year-old surely he or she knows what a granny is. He or she knows what, even if it was a year prior to, a year's lapsed, if the child was 6, I'm sure they will still know who's granny and grandpa. Because sometimes that's also a way of, I'm not saying the child must choose, but just to get an indication of what is the attitude of the child towards this grandparents. You might be surprised, this child might have a very good memory and good experience of the grandparents, and that might be a factor that the court can say, yeah, no, but clearly the mother has her own issues with the grandparents, which usually, that's usually the problem, but the child has no issues with the grandparents, and it seems to be there is a need for the child to have contact. If you can't do it sort of with child participation, then going to a social worker, might be your other option, so that the social worker can have a bit of a, I don't even want to say an investigation, but maybe just a look at the needs of the child in terms of having contact with extended family.
Okay, but then just last question, but what if the parent has gotten to the point where they've poisoned this child so much that the child, let's say it had the most amazing relationship with the grandmother, but now because of this and because of the poisoning, the child has now, obviously, the mother's view is printed into him, or he is scared, for example, to say, yeah, I would like to see my granny, because he knows the mother would be angry about it.
Yeah. You see, that's why I say if you look at the earlier case law in terms of with regards to grandparents, there was this idea, and it also was confirmed in the later case law, that if that contact is going to lead to conflict, whatever the reason for the conflict is, it cannot be in the best interest. And also, I know there was case law that says, but if the mother is the primary caregiver, the court, I think the court's attitude was that who's the court then to intervene and override her? Yeah. You know, whatever the reason for her decisions. So for me, I always say, what's the bottom line? The bottom line is, will this contact lead to conflict? And if the answer is yes, it's all very good and nice, and it's nice to have grannies and it's nice to have grandfathers, but is it nice enough if there's constant turmoil and conflict in the children's lives then?
Okay, no, I hear you 100%.
Yeah.
Answer is quite straightforward. There will be conflict, but okay. No, thank you.
Oh, but I mean, see what the 7-year-old. I know it's you know, maybe the child will surprise you.
Okay, but thank you for your answer. I really appreciate it.
Okay, that's fine. Okay, any other questions? Okay, then that's fine. Okay, then you must have a very nice evening and good luck with the last portfolio. And yeah, then good night.
Good night. Thank you.
Thank you.